Hi guys, good morning. Okay, so in this video guys, we are going to um, read the books, no? Uh, Judicial Department, Article VIII of the Constitution. Karon di ay, it's already 3 o'clock in the morning. So, good morning. Then, December, unsa ron December? Wait sa guys ha. Unsa pizza na ron ay. Basta basta no. Friday ron, okay. So Friday. Then walay klase ron guys. Ang walay klase ron diri sa Argao kay naam ko'y gitawag og kanang DFOOT or Division Festival of Talents. Then gi-advance ang gi-allow ra nga ipa-advance ang Christmas party sa mga bata sa eskwelahan, o also the Christmas party para sa mga teachers. Kay again naay Division Festival of Talents nga i-held diri sa Argao. Okay, so that's why karon Friday nami gahapon nag Christmas party ang mga bata, mostly tanang mga school diri sa Argao kay nag Christmas party sila. Then karon pod ang Christmas party sa mga teachers. Gahapon natay dahang basi wala tay kanang advisory, no? Basi wala tay advisory sa school. Natay mga invitation gikan sa mga classroom, but wala ko kaadto, no? Wala ta ka attend sa invitation kay yesterday we had our meeting with the technical working group. So nani maguni siya guys, no? Na-appeal ko sa technical working group sa Araling Panlipunan, no? So unani maguni siya ka kuan kanang unani ni siya ka complicated ang akong schedule, ang akong position guys. I graduated actually I am a graduate. I finished Bachelor of Science in Information Technology. Then I don't know how did the PRC come up with a decision that those who are graduates in other different programs other than education, then kung magkuha sila units of education kay magkuha sila let ato nila i fall sa social science, major in social science. So mo na siya ano to, ay social science ba to, or basta Araling Panlipunan kaigo, no? So mo na nahitabo nga kay ni ko munta ka nang when we in undergrad we are a scholar sa DOST. So that's why part of the scholarship agreement, I have to teach in any public and private schools in the Philippines. Then if I want to have a permanent position in DepEd, I have to pass the LET. So that's why in my first year in teaching, when I already got the item in DepEd, so I enrolled in some education units in CTU Moalboal, and there took the exam, licensure examination for teachers. Then we pass. So mo na siya, mo na nitabo. In DepEd, I am part of the Araling Panlipunan Department. Even though we are an information technology graduate. So that's why during the yesterday, I am part of the technical working group to facilitate the conduct of the events in under the Araling Panlipunan Department, no? In the division Festival of Talents. So nana na siya. Then we had a meeting yesterday, so we were not able to be in the party sa mga classroom sa mga bata dito sa school. So mo na siya. Then we finished the meeting almost 11 o'clock. Then I decided to stay in my house to study this book article. So I finished reading the Article VII, the Executive Department, yesterday. So now I will start reading the Article VIII, the Judicial Department, in this book of Bernas. Now let's start, guys. Okay, so section 1 of the Article VIII, the Judicial Department. The judicial power shall be vested in the Supreme Court and in such lower courts as may be established by law. So based on our readings, Article 6, Section 1 states that the legislative power is vested in the Congress of the Philippines. And Article 7, Section 1, the executive power is vested to the President of the Republic of the Philippines. And Article 8, Section 1, the judicial power shall vested to the Supreme Court of the Philippines and in such lower courts as may be established by law. So let's start. Okay, so ano man siya, guys, no? At yung sundan siya basa because this will be the last coverage in our Consti 1. So mas mainim magbasa ta para dili ta magangay ni discuss atong professor, because I found it very interesting that our professor is very good in handling the subject. Some of our students kaon sila kanang nangatras na wala na, dili na kaya. So that's why our brave heart will tell us to fight. Okay, so judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Okay, so that is the judicial power, no? Includes the duty of the courts of justice to settle actual controversies. Judicial power. In a society which looks to the judiciary as the last bulwark of constitutional rights and liberties, one can be spared the agony of disappointment over silence of judiciary about critical public issues if one takes the trouble to find out what the role of the judiciary is in the constitutional scheme. Courts are given judicial power, nothing more. Judicial power, therefore, is the measure of the allowable scope of judicial action. Hence, a proper understanding of the concept is essential to understand of the role of the judiciary. Judicial power has been defined in jurisprudence as the right to determine actual controversies arising between adverse litigants duly instituted in courts of proper jurisdiction. It is the authority to settle justiciable controversies or disputes involving rights that are enforceable and demandable before the courts of justice, or the redress of wrongs or for violation of such rights. Thus, there can be no occasion for the exercise of judicial power unless real parties come to court for the settlement of the actual controversy, and unless the controversy is such that it can be settled in a manner that binds the parties by the application of existing laws. The exercise of judicial power, however, goes beyond the mere promulgation of the final decisions. The exercise of judicial power, however, goes beyond the mere promulgation of final decisions. Okay? So, the exercise of judicial power, however, goes beyond the mere promulgation of final decisions. In Ichigaray versus Secretary of Justice, the famous case of Ichigaray, no? The one that is the first person who was convicted and punished of death penalty, where the sentence of death had become final and executory. The Supreme Court issued a temporary restraining order delaying the execution of the sentence. Against the contention of the court had violated the rule on finality of judgment, and even encroached on the President's power of executing clemency. The court replied that the power to control the execution of its decision is an essential aspect of jurisdiction. It cannot be the subject of substantial subtraction. It cannot be subject of substantial subtraction because the Constitution vests the entirety of judicial power in one Supreme Court, and in such lower courts as may be established by law. The court added that the most important part of litigation, where supervening events may change the circumstance of the parties and compel courts to intervene and adjust the rights of the litigants to prevent unfairness. The court added that the most important part of litigation, whether civil or criminal, is the process of evaluation of decision where supervening events may change the circumstance of the parties and compel courts to intervene and adjust the rights of litigants to prevent. Regarding Ichigaray, what persuaded the court to delay the execution was movement of Congress to amend the law on capital punishment. The court decided to await the outcome of this movement. Also, to claim that the action was an intrusion into the President's power of executive clemency, the court replied that Article VII, Section 19 cannot be interpreted as denying the power of the courts to control the enforcement of their decision after their finality. In truth, an accused who has been convicted by final judgment still possesses collateral rights, and these rights can be claimed in the appropriate courts. The death verdict, who becomes insane after his final conviction, cannot be executed while in a state of insanity. According to the court, the death verdict, who becomes insane after his final conviction, cannot be executed while in the state of insanity. The suspension of such death sentence is undisputably an exercise of judicial power. It is not a usurpation of presidential power of reprieve, though its effect is the same. It is not a usurpation of presidential power of reprieve, though its effect is the same. The temporary suspension, the temporary suspension of the execution of the death verdict. The court compared this power to the power of Congress to amend the death penalty. The powers of the executive and legislative and the judiciary to save the life of the death convict do not exclude each other for the simple reason that there is no higher right than the right to life. To contend that only the executive can protect the right of life to an accused after his final conviction is to violate the principle of co-equal and coordinate powers of the three branches of our government. Co-equal and coordinated powers of the three branches of our government. Intrinsic limit on judicial power. So we have intrinsic and extrinsic. Sana ni siya? Because all is given to the judiciary, because all that is given to the judiciary is judicial power by the principle of separation of powers, courts may neither attempt to assume nor be compelled to perform non-judicial functions. Because all that is given to the judiciary is the judicial power, by the principle of separation of powers, courts may neither attempt to assume nor be compelled to perform non-judicial functions. An early case which dealt with the attempt to impose non-judicial functions upon the Supreme Court was Manila Electric Co. versus Pasay Transportation Co. It dealt with the statute granting a franchise to an electric company. Section 11 of the statute said, whenever any franchise or right of way is granted to any person, to any other person or corporation, now or hereafter in existence, over portions of the lines and tracks of the grantee herein, the terms on which said other persons or corporations shall use such right of way, and the compensation to be paid to the grantee herein by such other person or corporation for said use, shall be fixed by the members of the Supreme Court, sitting as a board or arbitrators. The decision of the majority of whom shall be final. In declaring Section 11 unconstitutional, the Supreme Court pointed the three defects of the statute, two of them closely related and having to do with the nature of judicial power. Examining the statutory provision which is here in bold, it is first noted that power is attempted to be granted to the members of the Supreme Court sitting as board of arbitrators, and not to the Supreme Court as an entity. It is next seen that the decision of the majority of the members of the Supreme Court is made final. The court then proceed to analyze this situation as representing the horns of dilemma. Either the members of the Supreme Court sitting as a board of arbitrators exercise judicial functions, or the members of the Supreme Court sitting as board of arbitrators exercise administrative or quasi-judicial functions. The first case would appear not to fall within the jurisdiction granted to the Supreme Court, even conceding that it does, it would presuppose the right to bring the matter in dispute before the courts, for any other construction would tend to oust the courts of jurisdiction and render the award a nullity. But if this be the proper construction, we would have the anomaly of a decision by the members of the Supreme Court sitting as board of arbitrators taken taken therefrom to the courts and eventually coming before the Supreme Court, where the Supreme Court would review the decision of its members acting as arbitrators. Or in the second case, if the function performed by the members of the Supreme Court sitting as Board of Arbitrators be considered as administrative or quasi-judicial in nature, that would result in the performance of duties which the members of the Supreme Court could not lawfully take it upon themselves to perform. The present petition also furnishes an apt illustration of another anomaly, for we find the Supreme Court as a court asked to determine if the members of the court may be constituted a board of arbitrators, which is not a court at all. So dila sa takaw to guys, kay taas na kaya itong video, then giduka na ko, boys ko tulog sa tag nga pinakalit, kanang mga kan ba, kanang itawag nilag power nap. Okay, so bye guys. So please subscribe to this video para to support me in my endeavor, in my journey to the law school. Then we study together, and we journey together to the law school. God bless.